Welcome to Law Help Australia, where we keep you safe and informed with tips and updates. Did you know that under Victoria's Mental Health Act, that came into effect on 1st of July 2014, that you can be compelled to undergo compulsory treatment? We're going to discuss that and the rights of the person in tonight's episode. But before we do that, let me introduce you to our panel. We have Robyn Mills from Victoria Legal Aid. Robyn, tell us a bit about yourself.
I'm Robyn. I'm from Legal Aid. I've worked in the area of mental health and disability law for about 22 years now, and I work exclusively with people with disabilities, including undertaking mental health tribunal hearings. And today, on my calculations, I did hearings 189 and 190 since the commencement of the new Act.
And we have Mr. Matthew Carroll, President of the Mental Health Tribunal. Tell us about yourself, Matthew.
Hi, Emily. Well, yes, as you said, I'm the President of the Mental Health Tribunal here in Victoria, which commenced operation on the 1st of July last year. With the Act,
yep.
That's right. Prior to that, I had been in the role of President of the former Mental Health Review Board and Psychosurgery Review Board since May 2010.
Okay. And we have our co-host, Dinesh Weerakkody. Tell us a bit about yourself, Dinesh.
I've graduated in 2004 from a very good university, that is Deakin University, and got admitted to the Supreme Court to practice law in 2007, and since then I've been practicing.
So we know the Mental Health Act came into effect on the 1st of July 2014. It's quite new. And it places people with a mental illness at the centre of decision-making about their treatment. Dinesh, tell us a little bit more about the Act.
The Act promotes and supports decision-making and encourages strong communication between health, practitioners, consumers, their families and carers. It supports people with a mental illness to make and participate in treatment decisions and to have their views and preferences considered and respected.
You said mental illness, so what exactly does that mean, Robyn? Can you tell us?
Well, mental illness is defined under the Mental Health Act. It's defined quite clearly in Section 4 of the Mental Health Act. And what the Mental Health Act says a mental illness is a significant disturbance of thought, mood, perception or memory. Now, there are a number of exemptions under Section 4. Under Section 4.2 of the Act, a person cannot be considered to have a mental illness by reason of only one of the following. That is, they refuse or fail to express political opinion or beliefs, or they express or refuse or fail to express particular religious opinions, that they have a particular philosophy or a particular sexual preference or sexual orientation or gender identity, that they have engaged in or refused to engage in political activity, that they've refused to engage in particular religious activity, that they engage in sexual promiscuity, immoral conduct, illegal conduct, antisocial conduct, have an intellectual disability, and that's very important. Just because you have an intellectual disability doesn't mean you have a mental illness. Likewise, if you use drugs or consume alcohol, or if you're a particular economic or social status or racial group, or if you've been involved in family conflict, and most importantly as well, just because you've been treated for a mental illness in the past doesn't mean that you now have a mental illness.
Right.
So there are a number of quite lengthy exceptions.
Right.
That really focus on people's characteristics as well and their beliefs. So I would say it sort of looks to their rights as a person too.
That's correct. And it's really saying just because you have a certain political belief or a certain religious belief that may not be shared by the usual members of the community, it doesn't necessarily mean you have a mental illness. And mental illness and how it's diagnosed is taken very, very seriously by clinicians and by the Mental Health Tribunal in looking at the Act.
Right.
That's very interesting. But Matthew, can you tell us what compulsory treatment is?
Well, an important first message, I think, is that the vast majority of treatment for a mental illness in our community occurs on a voluntary basis. But there can be situations where a person is experiencing a a relapse or an emergence of a mental illness, and in their present circumstances it's not possible for them to be treated on a voluntary basis. For instance, they simply may not be able at a particular point in time to provide informed consent to treatment. And the types of conditions that typically underlie the need for compulsory treatment in terms of the people that are seen by the Mental Health Tribunal, the most common conditions are schizophrenia and a major mood disorder, such as bipolar affective disorder.
Wow. So tell us a bit more about what the tribunal does.
So the tribunal becomes involved in a person's compulsory treatment at particular points in time or defined points in their treatment pathway.
Is that by, say, a psychiatrist or treating practitioner bringing an application to the tribunal?
There's a slight mix. When a person first presents and it's felt that it's necessary for them to be treated on a compulsory basis and they meet the criteria for compulsory treatment under the Act, an authorised psychiatrist can make what's called a temporary treatment order that allows compulsory treatment for a maximum period of 4 weeks. In that 4-week period, it's the responsibility of the tribunal to convene a hearing, to hear from everyone involved and make a decision about whether or not a person should remain on a treatment order.
So without any application from an applicant, is it, or just?
So that hearing within the first 28 days happens automatically. No one needs to initiate it.
Right.
A person who's being treated compulsorily, the instant that they are a compulsory patient, they can make an application to the tribunal for their order to be revoked, and that will also trigger a hearing. But as I said, it's important to note that they don't need to do that for the tribunal to become involved.
Right. And what are the other ways that the tribunal will?
The other points at which the tribunal is required to convene a hearing is if, say, that 28-day hearing, or when it's heard an application for revocation by a patient, the tribunal makes a treatment order. It will specify how long that treatment order is to run for. And a treating psychiatrist, when the order is nearing its expiry date, can make an application to the tribunal for a further treatment order if they believe the criteria are met for ongoing compulsory treatment.